Yo, hey, what's going on, everybody? This B, this is Yo. Welcome to Man Views, where we cover everything that is fatherhood related, manhood related, and overall adulthood related. So usually I'll make interviews, with the BOK podcast. But for today, we are going to react to, a video regarding child custody matters in the courtroom. The goal is to really react to these kind of videos because, you know, one thing I want to do is put a spotlight on, I'm talking about like put a spotlight on certain type of moms that get away with certain things. Society don't really see that side of the courtroom, family courtroom. They think it's just man being deadbeat, but y'all not seeing what fathers have to go through with their BMs. You know what I mean? So without further ado, let's just watch the video and I will provide feedback here and there and comment here and there. So this particular video is by this YouTube channel called Family Court Chaos. Props to them. Give them some shout outs. But yeah, let's go through it and then and then for quick little background, I provide, custody, coaching and also co-parenting strategy coaching for those that don't know. So I have a lot of experience in this matter and I can give you some input on what to do and what not to do. All right, let's go.
7th Circuit Court is now in session with the Honorable Brian K. Kirkham presiding, calling case 2022-2134 DM Aaron Gentry versus Peter Gentry. Today is Monday, December 23rd, 2024 at 9:36 a.m.
Court will note the appearance of Ms. McNiff on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. This matter is before the court on the defendant's motion to require plaintiff to comply with the judgment of divorce. Obviously, I've read the pleadings in this matter, Ms. Thomas. You don't have to reiterate those. Do you have anything in response to Ms. McNiff's answer?
Well, there's a lot of things to respond to because there was a lot of inaccuracies in there.
Well, let's respond to the salient points. There was a lot of ancillary and I believe superfluous stuff included, and I don't need you to respond to that.
Okay. All right. So the issue is, of course, whether or not and when Ms. Tinsman has to respond or has to remove his name from the obligation. The concern is that now we've learned that her intent is to not do so for another 18 months. The problem, or to even list the house for sale for another 18 months, which would even be beyond that. But the problem of it is that it's affecting Mr. Gentry's credit. It's affecting his ability to do other things at his house and ownership of his house. And so it was supposed to be to hold him harmless. And in the response, there's several things that aren't true, including, who had the affair. I mean, there's all kinds of things. But again, as you indicated, they're ancillary things. The bottom line of it is this case was one where Ms. Tinsman's attorney drew up the document. Mr. Gentry was not represented. It was after he had met with both of the parties, and they both were of the understanding at that point that she was going to refinance and get this taken care of right away. It's now more than 2 years later, and nothing's been done. And it seems that Ms. Tinsman is of the belief that she can do this if and when she wants to. And it is affecting his credit. It is affecting, there's all kinds of excuses, but every excuse is one that frankly is under Ms. Tinsman's control. We just are asking for a date by when it needs to be done, because one wasn't put in the initial judgment of divorce that was prepared by Ms. Tinsman's attorney. And then again, the amount of things in the response were a little flabbergasting for us, quite frankly, but there are 5 missed payments according to the document from the credit union. And so we're just simply asking that there be a timeline put on this matter.
Okay, thank you.
Okay, let me pause real quick. So quick thing, here's what not to do in a courtroom, whether it's virtual or in person. So whenever the other party's talking, you see how this lady right here keeps shaking her head. I guess this is the mother of his child. So a quick background, she brought him to court to request more money from the ex-husband. Now, her keep on shaking her head, whether they're lying or not, you don't do that. Just sit back, relax, let them say their part, and then you have your chance to speak. Judges don't like when the other party constantly shaking their heads and trying to, physically interrupt.
Ms. McNiff, you talk about all sorts of things in the response. What's the date that she'll have this refinanced by?
Your Honor, as we responded in detail, the problem she's going to have is that the financing companies want her to have 2 years of either W-2 or 1099 wages. And she simply doesn't have that. And so she won't be able to refinance until then. She certainly wants to sell the house sooner than 18 months. But we need a resolution of the parenting time issue. I have to file a motion, I think, to resolve that and to get that to a hearing.
Okay,
But
that's not before me today.
No, I'm just, and I understand that. She has an
Give
intent
me
to
a date.
sell.
Give me a date.
I don't have a date, Your Honor. I don't. But the big thing here, Judge, is a judgment of divorce for the property provisions is really a contract. And it's not for the court to reform the party's contract. It should have been on Mr. Gentry to ask for a date when he wanted his name off of that property. And without that being in the judgment, there is no date. I think that
Okay, that's fine.
Mrs. Tinsman will do it, but the judgment speaks for itself.
Okay, well, in this matter, it's been approximately, the judgment was back in on February 13th, 2023. So we're going on close to a year. Obviously, that's sufficient time to get the matter resolved, and the court's not going to wait indefinitely for the plaintiff to qualify or whatever. And because we can't be given a date, the court is going to order that the house be sold, listed for sale forthwith, and be sold. If something happens in the meantime, she's able to refinance, the court would consider that. But at this point, if there's no date, that she's going to have to list it for sale and have it sold forthwith, and provide Ms. Thomas with the listing agreement. I will require that be done within 14 days of today's date.
Judge, could she have a little bit more time just due to the holidays? It's going to be
She's had
difficult.
sufficient time. She can do it within 14 days. Thank you.
Okay. Thank you, Judge.
You got it. You can submit that, Ms. Thomas, under 7 day.
Will do. Thank you.
Thank you. Have a good day and a good holiday.
Thank you.
Thanks, you too.
9:19 a.m.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. Thomas on behalf of defendant. Matter is before the court on the plaintiff's motion to modify parenting time. She says, due to the intent of the plaintiff to move to Virginia. Go ahead, Ms. McNiff.
Thank you, Your Honor. I know the court is familiar with this case and has read the pleading, so I'd like to just respond to the answer if that's acceptable to the court.
That's fine. I don't need a reiteration of everything in the pleadings.
Thank you, Your Honor. First of all, we're offended by the fact that in the answer, they indicate that my client became pregnant with her boyfriend. In fact, my client was engaged to her now husband when they had an unplanned pregnancy. We feel like that's simply a dig that was unnecessary in the answer. But the big issue here is that Attorney Thomas indicates in her answer that the referee could have set up a parenting time plan after the change of domicile hearing, but didn't based on the children's best interest. The fact is that the time of the hearing, there was no request by either party to have a change in parenting time if there was no change in domicile. The request was to change the domicile and change the parenting time in conjunction with that change of domicile. The court denied the change of domicile and simply did not have a change of parenting time because that request wasn't on the table. Mrs. Tinsman has now made the decision to accept that finding and intends to move to be with her husband and their infant child in Virginia at the time that the Battle Creek house sells. While the court certainly has the authority to prevent the children from moving to Virginia or changing their schools, Mrs. Tinsman is free to move to be with her husband as she sees fit. Mrs. Thomas believes that the parties can continue with the current week on, week off parenting time schedule even after my client moves to Virginia, but that's simply untenable. It's ludicrous to think that anybody could do that. Mrs. Tinsman has a 7-month-old child who will eventually turn attends school. The party's youngest child is 6. To think that Mrs. Tinsman can travel every other week from Virginia to Michigan for the next 12 years is absolute insanity. She can't afford to buy a residence in Michigan now that her house has been ordered to be sold, and she can't afford the high cost of rentals on a bi-weekly basis. There needs to be an alternative parenting time plan put into place that accounts for this move. This is going to be a big issue when this house sells. Ms. Thomas argues that the house selling and Mrs. Tinsman moving is not an ordinary life change, but she's simply wrong, and it's absurd it's an absurd argument that this court should absolutely not entertain. Selling the family home and moving out of state is absolutely an ordinary life change as contemplated in Shade v. Wright. We could wait until the house sells and then renew our motion, but we think that it makes sense to prepare for this eventuality in the event that the house sells very quickly. The court ordered that the house sold. There is a listing agreement. The listing for the house is going to go live this coming weekend with photographs, and we would anticipate that it will sell fairly quickly. Ms. Thomas also indicates that we're asking for a 50-50 parenting time split, which she knows is absolutely untrue because she sent us a proposed parenting time plan and we sent a counteroffer, and neither contemplated a 50-50 split. It's simply ridiculous to think that the parties could live in Virginia and Michigan and have a 50-50 parenting time split. We know that can't happen. She further argues against herself, saying on the one hand that an equal time division isn't necessary for joint physical custody, and on the other hand insisting that Mrs. Tinsman maintain the equal division of parenting time by commuting. We understand that there can't be a 50-50 split. We've never been proposing that, even when we were asking for a change in domicile. I'm frankly incredulous that Ms. Thomas alleges that Mrs. Tinsman wants to take away all of the school holidays from Mr. Gentry when she knows that that is absolutely false. Mr. Gentry's offer was in accord with our counteroffer, and the parties were in agreement on all of the major school holidays, including Memorial Day, Labor Day, Martin Luther King Day weekend, the midwinter break, the spring vacation, the Christmas vacation, and the Thanksgiving vacation. Where they got hung up on was how much time each of them would have during the summer vacation, the Independence Day holiday, and who would pay for transportation. Those were the big hangups. So to say that we're asking for all of the school holidays and making that seem like my client is being selfish is absolutely fallacious, when that was part of a proposal that they sent to us. The big issue here, Your Honor, really is who's going to pay for or provide the transportation for the parenting time when my client moves to Virginia. This court's policy in the past to not necessarily make that an equal division. The moving party should bear perhaps more of it, but it's also never been this court's policy that one party has to bear the entire burden of transporting the kids for parenting time. We're not asking that there be even a 50-50 split of the transportation burden, but we are asking that Mr. Gentry be required to do some of the transportation, perhaps for the big holidays like Christmas and summer and spring break, Thanksgiving, things like that. Further, Ms. Thomas complains that we haven't complied with the order regarding the sale of the house, which is again absolutely false. The order that Ms. Thomas drafted specifically provides that we were to provide a listing agreement 14 days from December 23rd of last year. We provided the listing agreement to her on January 6th of this year, which was within 14 days, in spite of the Christmas holiday and in spite of the New Year holiday. Mrs. Tinsman was scheduled to meet with a realtor prior to January 4th, but the realtor contracted pneumonia and had to move the meeting to January 4th. The realtor then asked Mrs. Tinsman to ready the house for photographs. There's 4 small children living in this house, and my client had to declutter, clean, make repairs, wash crayon marks off walls, and do things like that in order to get this house ready for sale. She's been diligently working on all of those tasks since her meeting with the realtor on January 4th. And the house is now ready for professional photographs, which will occur on January 16th this week. And the listing will go live this weekend. The realtor felt that it's better to go live on a weekend in order to generate more interest and also to have the house decluttered, looking good for the photographs so that people will have more interest in the house. Your Honor, this shouldn't be a difficult case. These cases come up all of the time. People are able to work through them. However, these parties can't, and we need the assistance of the court to try to figure out a proper parenting time schedule that will maintain joint physical custody, although we're not asking for 50-50 time, and accommodate the fact that my client wants to move to Virginia to be with her husband and their small child. The way we see it, the big differences are the summer vacation and how many weeks each party will get during the summer vacation, the 4th of July holiday. My client is looking for 1 weekend per month during the school year to be exercised in Michigan. And she would do all the transportation for that. And we're looking for some kind of division of the transportation.
All right, before the judge go in, listen, man, quick thing. If you decide to move, if we have 50-50 custody, you know, what the state or the place the child was born, and that's what the domicile is pretty much is, right? That particular state or county. And you and your husband decide to move, that's y'all's doing. That's your choice. You know what I mean? That means you will lose more custody of the child. It is what it is. Either you remain or you move. Once you move away, you are giving up those extra days and overnights with the child. It's not too simple, but let's see what the judge got to say.
Thank you. Ms. Thomas?
Your Honor, a couple of things. First of all, that was not, I mean, the specificities of the parenting time was certainly not before the court, but the bottom line of it is, though, that in fact, the motion that Ms. Gentry Tinsman filed with the court initially was a change of domicile and a change of parenting time. Clearly, that motion seems to have purported that if in fact there was a move, parenting time would have to change. And that's fine, but throughout the course of that particular hearing, and which was like 13 months, Mr. Snyder considered a variety of things, and specifically, he noted in his finding that Ms. Gentry was going to have to make some specific decisions about, did she choose to live with her children in Michigan or be in Michigan with her children, or did she choose to be with her husband and a new child, and that decision would be very, very difficult for her, and it's in the finding. So clearly, the court heard very significantly, in fact, about the new child, and again, there was no intent about boyfriend, fiance, not husband at any rate. Her husband, her child, the fact that she intended to move. So the court knew all of those things, and still, even though parenting time was before the court, did not fashion any kind of order that if in fact, and after specifically stating that she would have to make these difficult decisions, did not in any way indicate, well, if she chooses to move, then it would be this parenting time. And the court had authority to do that and could have done it, but the court didn't do it. And it's we find it, I find it very interesting this morning that specifics of the what the specific issues are between the parties was brought to light when Ms. McNiff last week was upset because I said anything that there was a motion or a offer at all. The bottom line of it is that for the last year and a half, Ms. Tinsman has gone back and forth. If she chooses to, I mean, yes, the court ordered the house to be sold. It is not listed at this point in time. Irrespective of what Ms. McNiff has said, at this moment, it's not listed. And it doesn't even have to be sold. This court specifically gave the option that if in fact she got it out of Mr. Gentry's name, that it didn't have to be sold. So that is another option. She's been doing it for a year and a half. I understand that that's a lot, but I also believe that Ms. McNiff was not quite 100% honest, and not that she's being dishonest, but she left out a few things. Number one, that the initial offer was the same as what they had put in their motion for change of domicile reversed. In other words, she was willing to go the extra mile to have Mr. Gentry agree that in fact her motion would be accepted, and ultimately expected us to do the same thing. Well, he didn't want the children to necessarily move. He doesn't necessarily want the children's mother to live that far away from them. Bottom line of it is there was an offer, we countered. Our counter offer from that, they asked for more time than they asked for in the very beginning. So that, to us, that wasn't even a realistic negotiation. At this point, the court has looked at the facts of the case, knowing that there's a new husband, knowing that there's a new child, knowing that the defendant intended to move. There's no change in those circumstances. She intended it before, she intends it now. And so I don't believe there is a change. Again, selling the marital home does not mean that she necessarily has to move. The house is in her husband's name as well. They can either pay it off.
I'm sorry, but thank you. I was waiting for that. I was waiting for her to say, just because you sold the house or selling the house doesn't mean you have to move. You could sell the house and move somewhere else nearby in the same state that you're in. You didn't have to move to a whole nother state, a whole nother place. You know what I mean? And quick fact too, so when they keep saying domicile, it's pretty much just saying the permanent place that the child is in, you know, that place, that's what the court have, you could say, order over. So there goes to change that, so that way she can freely move around. But long story short, just because you're trying to sell the house doesn't mean you have to move. If you want to move on your own, it's a very tough decision. You got to decide, you and your husband. But that's y'all. Why should the child and I pay the price because you want to move? So that's what this was going on overall.
Or refinance or somehow get Mr. Gentry's name off the mortgage, that would comply with the court's order. And again, the status quo for the last year and a half has been going back and forth. Although Ms. McNiff has indicated that they're not asking for 50-50, Ms. Tinsman continues to refer to a plan wherein she could move and maintain joint physical custody of the parties' children. And as Ms. McNiff indicated this morning, it is unrealistic to assume, because plaintiff's unilateral choices that and her wants and desires, that she would solely determine the children's time with their dad either. As pointed out in our answer, again, it doesn't have to mean 50-50. And depending upon her choices, she can continue with equal parenting time if she wants to, or she chooses to stay in Michigan. But she wants to move and she wants to take the kids away from their dad and their friends and it's not, when we're talking about school holidays, we're not talking about it. The intent was not to talk about holidays as in Memorial Day, but holidays as in the non-school time. Clearly, it would not be equitable or in the children's best interest to never be able to have vacation time with their dad, because their entire summer would be with their mom. And that's a big part of what Ms. McNiff did leave out in what she indicated to the court this morning. The court has already said and ruled when Ms. Tinsman asked last summer to take summer parenting time in 2-week increments, that no, it's not in the kid's best interest. And so even though it would have been more convenient for her. So bottom line of it is, Mr. Gentry wants the kids to have a meaningful relationship with their mom, and he's willing to work with her. He offered a parenting plan, which quite frankly was a little more generous than what I thought that he would offer, or that I thought, quite frankly. But it would allow regular continued parenting time with the children if mom chooses to move. That was declined, and more parenting time than what had initially been asked for was asked for. The plaintiff suggested resolution wherein the kids would no longer enjoy extended summertime with their dad, where plaintiff's parenting time would not be supportive of the kids' events and activities. That's not focusing on the kids, or it's not putting their best interests first, and therefore it's not acceptable to Mr. Gentry. And quite frankly, it's also not in compliance with Michigan court case law. Your Honor, the court has heard about plaintiff's new husband, the new child, her desire to move, her intent to move. She's brought up nothing in this particular motion that's not already been before the court, and frankly, to ad nauseum. And frankly, she's not met her burden of proof for a change of parenting time. Frankly, Mr. Gentry can't continue to pay for ongoing attorney fees merely because the plaintiff doesn't like the prior orders of this court. He's praying his request for attorney fees will be granted so that the ongoing motions will stop. Again, whether this court orders an evidentiary hearing or not, Mr. Gentry is willing to work with Ms. Gentry with regard to, or Ms. Tinsman with regard to the parenting time, but to have this ongoing, constantly, forever in front of the court and expense, he can't afford to continue doing it when it's every time it's been because Ms. Tinsman doesn't like the last order of the court. So we're asking that the motion be denied, and that first of all, it may not be right because she's not moving right now. But again, there's options. It's not, the only option is not that she would live there and the kids would live here and she couldn't have alternate week parenting time. She can if she wants to. The house doesn't have to be sold. The court didn't order that. The court said if she wanted to, that the court would consider refinance or paying it off or whatever it would have to be. I don't believe that this is a motion that is well advised. I believe this court has already heard this, and Mr. Snyder, I mean, it took him a long time to do his finding. And I know that both Ms. McNiff's office and my office are both saying, when are we going to get the results? Because it did take him a long time because he put a lot of careful consideration into this. And to now go back and do a redo doesn't seem necessary. First of all, I don't believe it's properly before the court showing a change in circumstances, but it also is very expensive. And Mr. Gentry can't just keep shelling out money because the order of the court isn't the one that Ms. Gentry or Ms. Tinsman would like. So we're asking that the motion be denied in its entirety.
Okay, thank you. Well, in this case, I do note that Ms. Thomas had stated that at the hearing that the referee had stated, and in fact had not fashioned any change in parenting time. And as she stated, apparently the referee had also queried again if the plaintiff was going to move. So there was apparently some uncertainty in that. It does sound now that she's moving, and obviously moving that amount of distance is a change pursuant to Shade v. Wright. And what the court does note is that the referee has the experience with this case, having gone through that. So the court is going to refer the issue of parenting time back to the referee for a hearing in which he can fashion a parenting time schedule, considering that the plaintiff is in fact moving to Virginia. So that will be the order, and court will do a referral order. Ms. McNiff, you don't have to do that.
If it was the other way around, and it was the father that decided he went out of nowhere, just move, and he was asking the same thing she was asking, the mom was asking, it would have been denied on the spot. They just take it so easy on the moms. Why waste time and have a whole nother hearing? You know what I'm talking about? I mean, all right, but before I go further, let me kind of break down some things that I liked and some things that I did not like. One thing that his lawyer, her right here, is she was just too choppy, bro. She was just like, no, when you dealing with these type of people, you gotta be precise. You gotta be on point. You gotta really be boom, 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 boom. Like, one thing about liars, I mean, I guess all lawyers lie, of course, but one thing about liars, like that kind of party, when it's the mother trying to, go against the father, they believe their lies. They'll be so accurate and so on point. I mean, even though it's all lies, not that they're gonna win, of course, but notice the difference. You have to understand, when you create a story, you gotta perfect that story. His lawyer, she was just too choppy. She hits a few key points, but the took some points away from it. But anyway, but she did okay though. But overall, man, like I said, this is crazy. So the honest truth is, if you guys have 50-50 and one party decides to leave, move away, yes, the parenting plan will be modified, right? Of course, it will no longer be 50-50. But that means whoever decides to move, you will have less parenting plan, less time sharing, we call it. You will have less time sharing plan because you decide to move. The county, the state, the child was born and spent majority of his or her life in. That's the domicile. That's the place that the child, that's the permanent address of that child. So if you move, the child doesn't have to move with you. The child will remain. You will lose time sharing. Well, the father will get more time sharing, but it's your decision. That's why a lot of time when folks are co-parenting, they can't just up and move. They have to be stuck in that state the child was born in and spent majority of his or her life in. They have to remain in that place. They can't just move. They just up and move, then they'll lose time sharing. Which then, if she was getting child support, then that means if she moves, that child support will be cut. Not only cut, but she'll have to pay him child support. And they brought up the entire house thing. The thing is, the court never told her she had to sell the house. Now, here's something that's very sad about divorces, right? Here's what's sad about this entire case. Number one, they got a divorce, okay? Number two, it was his house. You could tell it was his house. Of course, as we all know, the ex-wives, the women get the house. Nothing new. So she got the house. His name is still on the house, by the way. So he still partially owns the house. But she's gonna get the house. She got the house. If she wants to, she can sell the house if she wants to. So she want to sell it, get some money out of the house. Now with her and her husband now, they're gonna go get that money. They're gonna sell the house. They'll make from selling the house. They'll get that money and then they'll go buy a whole new house in a whole nother state. Another crazy thing. How crazy it is, bro, to be in the courtroom, wasting money in the courtroom, and going head to head with the mother of your child that's being freaking slimy, and y'all have the same last name because she still haven't changed his last name yet. It's crazy. It's insane to me. You know what I mean? But yeah, man. Overall, man. Look, I'll keep doing more and more of these kind of videos, but the last thing I'm gonna say is for her, I guess, husband now. Fellas, pay attention. When you date a woman with a child, before you get her pregnant, even after, watch how that woman treat the father of her child. Before you get her pregnant, before you marry that woman, get her pregnant, pay close attention how she treat the father of her child. I sad to say, if you watching your, I guess in the husband case, your wife now, back and forth in court, giving the father of her child, of their child, it's not her kid. A lot of moms think the kids are her kid. It's of their child. If she's giving that man hell like this, making that man blow money like this, what would happen when you get a divorce? You're not that special, buddy. A lot of men think that they very special. A lot of women think they're very special. A lot of women be like, no, not me. You want that to me. This man that's going through this right now, he probably thought the exact same thing. Look where he at now. Look at his face. You could tell he have a lot of regrets. One thing he did good, I give him props on, he just stayed calm the entire time. He didn't make no commotion, physically. He didn't shake his head. No, he didn't say, nah, she's lying. But notice how the entire video, kept shaking her head. Like a goddamn bobblehead. Right? He just stood still, let his lawyer do all the talking and all the reaction. I mean, I'm paying you all this money. I'll leave it up to you. But to her husband, be very careful. You are not that special, bro. If she could do it to her ex-husband, she'll do it to you. Like, what? Fellas, that's my biggest advice to y'all. Before you date a woman that have a child or that was once married, ask her, or at least ask the ex, how was it? Watch what she do to that ex. If they're in the courtroom, she's acting like this, she's saying this, saying that, and making it hard for the child and the father, you will be next. But anyway, look, hope y'all enjoy this. If y'all want to see more and more videos like this, reaction videos, let me know. And like I said, the goal is to put a spotlight on the things fathers go through inside the courtroom. Because a lot of times the world, the society doesn't really see this portion or this part of what fathers go through. All they do is just really hear one side of the story, which is, BMs going around saying men are deadbeat and men is bad and fathers are deadbeat, fathers are bad, etc., etc. But in the reality, here's what they're doing inside the courtroom. Here's what they're doing behind the scenes. Here's how they trying to make these kids be fatherless. You know what I'm talking about? So I'm going to make more and more videos like this. Oh, by the way, subscribe to this channel. Follow us on social media, manviews.org. That's manviews.org. And for any fathers out there that's going through it, they're either having a hard time co-parenting or having a hard time in their custody battle, don't know, what to do, where to go, what to say, or if they represent themselves. Even if you have an attorney, that's very costly. You can still get at me, right? So book me for a one-on-one, for a custody coach, and also for a co-parenting strategy. Just overall, your entire case, you being a father, I can get you right. So go to manviews.org. That's manviews.org. Book me for a one-on-one. We'll sit down and I'm going to give you all the gems, bro. I'm going to give you every single thing. My main goal will be to make sure you have your child in your life and to make sure your child have you in his or her life. At least 50-50 custody. All right. Share this video. But yeah, man, see y'all next time. And but look, as always, fathers, I got y'all, man. You know what I'm saying? Just be easy, be careful. And the last advice I'm gonna say to every dad that's going through custody battles: remain calm. Let your BM self-destruct herself. She's gonna lie. She's gonna defame your name, your character. She's gonna play victim. She's gonna use everything in her power to try and make your or y'all kids or kid be fatherless. Remain calm and document. I'm B the CEO. Catch y'all next time.